what is negligence? In order to prove a negligence claim, you have to show certain elements. That is, you have to prove certain things for a court to find that another party was negligent. The first element is duty. You have to show that there was a duty between the parties. The second element is breach of that duty. The third element is causation. And the fourth element is damages. So I'm going to dive into each one of those elements right now. First, duty. There has to be a duty between the parties, and that's a legal duty. This duty arises based on the relationship between the parties. So, for example, your doctor has a different duty to you than you would have to some random person on the street. At the minimum, though, we all owe one another a duty not to harm the other person. And then when you get into the different types of relationship, that duty changes to where doctors and lawyers and other professionals owe a special standard of care towards another party. So first, you have to show that there was a duty. And the second element is you have to show there was a breach of that duty. That is, that the other party did something that breached that duty, whether they didn't perform the obligations that they needed to perform, whether they actively harmed you. That's what breach looks like. The third element is causation, and courts tend to break this down into two sub-elements. The first is causation in fact, and the second is proximate cause. So causation in fact means that the breach of the duty, whatever the other person did that hurt you, did in fact cause the injury. So it can't be this attenuated number of events that didn't actually cause the injury. There has to be a direct relation there. And that leads me into the second one, which is proximate cause, and that relies on a concept known as foreseeability. It had to be foreseeable to the defendant that their breach of duty would cause the type of injury that it caused. These elements get kind of wrapped into one and just called causation. Essentially, what they did had to cause your damage, which is the fourth element, damages. Whether that is injuries or emotional damages, really the important aspect about damages, as it is with almost all other claims, is the monetary aspect of those damages. You have to be able to quantify those damages in some way. A lot of the type of negligence claims that we see that you might be familiar with are things such as companies not having policies and procedures in place to prevent injuries. So companies causing injuries in the workplace. Or in the environmental aspect, companies doing something that causes harm to the environment that then harms you. We also see negligence in a new area of law, and I think that this relates to some of the growing movements in the country, and we're seeing that in the law regarding sexual relations. So you have a duty to your sexual partner to not intentionally withhold your STD information from them. Negligence is a really broad area of the law, so it covers a lot of different types of relationships. So again, you have to show that there was a duty, that someone breached that duty, that it caused your injury, and that it caused damages. Now, as to how you defend against a negligence claim, it relates directly back to those four elements that we described. You can show that there was no duty, or that the duty that the other party is alleging isn't the actual duty that existed between the parties. You can also show that you didn't breach that duty. So that's a common defense in, for example, medical malpractice claims, because the doctors are saying that they performed to the standard of care that they're required to perform at. The third defense is that the breach of the duty, even if there was one, wasn't the cause of the injury. And another defense is that there were no damages. So that's negligence in a nutshell. It's a very broad claim. It's a claim that encompasses a lot of different types of relationships, and it's an evolving claim as we're seeing these days.